Good morning. Are you Brandon Henderson? And will your client waive the formal reading of the motion?
Here we are.
Mr. Henderson, in clause number 22-40931, I have a motion to revoke your community supervision. Shows that you were placed on probation June 13th of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you committed the new offense of aggravated assault February 26th of 2025 in Montgomery County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of unlawful carrying a weapon in Montgomery County on February 26, 2025. And is that true or not true?
True.
Count 3 alleges that you did not provide verification of performing the community service hours as required. And is that true or not true?
No, that's not true. I did
Okay.
most of my community service.
Okay,
for myself.
that's fine. Count 4 alleges that you are behind in your court-assessed fees. And is that true or not true?
True.
Count 5 alleges that you failed to remain in the state of Louisiana and that you were in Montgomery County on February 26, 2025 without permission.
True.
Count 6 alleges that you failed to report to the Jefferson County Probation Department by mail-in or online for the months of October, November, and December of 2024, and then January and February of 2025. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 4, 5, and 6 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
State,
Just so the court
Yes.
is aware, he received 2 years on the case in Montgomery County. That has been disposed of to, according to their office.
okay, thank you. State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Henderson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your plea of true to those counts freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find counts 1, 2, 4, 5, and 6 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That sentence will run concurrently or at the same time as your Montgomery County cases. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234, and that is for a misdemeanor offense or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court-assessed fees, that she admitted to using alcohol in violation of her probation, August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kimler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the 2 cases before you, she has 2 separate
DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from, is what's listed in the motion. It looks like the only thing holding her is the bond on this case. And if she's, in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask that be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. But if she does have the, I don't think she needs to drive at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just gonna put off. And so obviously if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without
Right.
it being approved by probation and ultimately by me, so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
It was just, that's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines, right?
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay,
And stay in touch with your bonds.
you can go back, yeah. All right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously, entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have each person here for.
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address.
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
I would ask him a few questions if the state's not gonna call him.
So I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st of 2020.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. And July 21st, he did not show.
That's what it's.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay,
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the three cases
Yes.
credited, is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes. Sorry.
May I proceed, John?
Yeah.
How long have you supervised, Mr. Patton?
So I'm a unit supervisor at our department. I've seen Mr. Perez on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
But you have some familiarity with him.
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes,
Proper decorum, all those things?
that is correct, yes, sir.
And should he be continuing on probation, you would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause you concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
But she was the one that was, I guess, directly supervising.
That is correct, yes, sir.
You have access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or?
Not that I've come across, no, sir.
That's what it is.
No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's gonna make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not, some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and aggravated robberies and all that. It's just a bad environment for me. and it puts me in a bad mood. Puts me, you know, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommendate MHMR, but I never went just because I felt like it was I felt kind of low, you know, of thinking I would go to MHMR, you know, because
Stigmatized.
yes, sir. So, at this point, I don't want to go to jail, to prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and you know, that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I-
Wait,
I'm sorry.
best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that from my ex-girlfriend, you know, just, you know, being dumb at the time.
No gang affiliation.
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant.
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
I always held a job. Even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out? You were a carpenter?
Yes, sir.
Scaffold builder? What were you?
We were doing woodwork, building decks and
Okay.
carports and lunch tents and that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not what.
I understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying to.
My understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot. You went there to go shoot Christy, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No, man.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the two girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him, and in the course of that, there was a gunfight, but he wasn't going there to shoot anybody.
All right, well, that's.
He was
again-
going there for an illegal purpose, to
That
have
goes
sex
against
with
everything
them.
that was said and everything that he agreed to back then, because,
That's correct, Judge. We were getting ready for trial on this case.
Yes, sir.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might
Sure.
have been killed, but he was there to go kill Christy.
I didn't represent him in
Okay.
that, so I don't know.
all right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending 2 other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address the, always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way of somebody just volitionally, or somebody just deciding to be stubborn and self-centered and not complying, but depression is a serious problem. He has struggled with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give him at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out, to follow up with Spindletop, to address not only any substance abuse problems, but any underlying mental health issues that may contribute to the substance abuse and just his ability to comply and just to continue on probation.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. The fact that you are on a probation for possession of a prohibited weapon, like you said, from back when you were 18 years old, put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been given opportunities to get help. I mean, you've been on probation since 2016 with every opportunity possible. So at this time, in cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. finds sufficient evidence to find you guilty, and at this time finds you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. And cause number 20-35328. Again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case. All three of these will run concurrently, which means together at the same time. I am going to hand you a trial court certification. These were not agreements. You do have some rights to appeal. You can talk to Mr. Kimler about that. I need you both to sign and fill out the bottom, and you'll get a copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right. I'm sorry?
It was 7,
12 and 12.
12.
Affirmative finding of deadly weapon on both of the two cases.
In a tense courtroom showdown, multiple defendants faced the consequences of repeated probation violations, violent offenses, and administrative failures. Brandon Henderson, Kaylin Salazar, and Robert Peets each had their own set of charges, ranging from unlawful possession of weapons to aggravated assault causing serious bodily injury. The hearings exposed a complex web of probation breaches, failed community service, unreported alcohol use, and past criminal history. Brandon Henderson admitted to aggravated assault and illegal weapon possession, freely pleading true to multiple counts. Despite attempts to justify his behavior, the judge found sufficient evidence to revoke his probation and imposed a 4-year sentence concurrent with previous cases. His acknowledgement of past crimes and failure to comply with court orders left the courtroom stunned, setting the stage for dramatic accountability. Kaylin Salazar, on unadjudicated probation for criminal mischief, faced allegations of DWI, failure to report, and incomplete community service. The judge granted her bond at $10,000 with strict conditions, no driving, and mandatory scram device monitoring. Her acknowledgement of an alcohol problem and intent to enter rehab highlighted the delicate balance between punishment and rehabilitation, keeping viewers on edge about the outcome. The most dramatic case involved Robert Peets, a repeat offender with a history of serious violent offenses. Peets admitted to probation violations and explained his struggles with PTSD, depression, and past trauma, including being shot and family tragedies. The courtroom watched as he detailed tattoos symbolizing personal loss and hardship. While some defense arguments highlighted his mental health struggles, the judge weighed these against the severity of his offenses. Peets' repeated failure to comply with probation and previous opportunities for rehabilitation led to a decisive ruling. The court handed down sentences totaling 7 and 12 years for aggravated assault and possession of prohibited weapons, with concurrent terms across multiple cases. Affirmative findings of deadly weapons were applied, reinforcing the seriousness of the crimes. The judge also issued written admonishments regarding ineligibility to possess firearms or ammunition, making the legal consequences crystal clear. Throughout the hearing, emotional testimony, probation officer insights, and stark courtroom exchanges emphasized the tension between compassion for mental health struggles and the necessity of justice. From the defendants' attempts to explain their actions to the judge's unwavering enforcement of the law, this courtroom saga demonstrates the dramatic stakes of probation violations, violent offenses, and repeat criminal behavior. When excuses collide with evidence and law, only one side prevails, and the verdict leaves viewers stunned.